Well, this could be one of the most mind-boggling videos that I have done to date as I travel further down into the overflowing sewer of the broken, incompetent and incomprehensible family court. And the word incomprehensible really stands out as I examine the issue that there is no, and it appears never has been, a Cafcass recommended accredited domestic abuse perpetrators program for women. Just that statement in isolation, that there is no accredited domestic abuse perpetrators program for women, is simply outrageous. Let me put it to you that no reasonable person can suggest otherwise. It is difficult to find the words to describe the potential bias, the imbalance, the inequality, the lack of fairness, the sheer madness of the situation. But I'm going to try and find those words, and as I do, I'm going to put all this insanity into context by examining the Cafcass website, the Cafcass Domestic Abuse Practice Pathway and Guidance, the DAPP fact sheet, and leaving no turd unturned in this sewer, the Equal Treatment Benchbook, published by the judiciary itself. But before we plunge into the mess, let me, as always, run my excellent introduction. I am Philip Kedge, a retired Police Chief Inspector, the Director of the McKenzie Friends UK Network and founder of the national campaign of #LightNotHate that places the welfare of children first by removing destructive and harmful lawyers from the family courts, who have absolutely no duty of care to any children. How disgraceful and sickening is that? In all my articles, my views and opinions are entirely my own. Please like, share, subscribe and hit that notification bell. Let's start off with the Cafcass website on the topic of the Domestic Abuse Perpetrator Programme. It states, the Domestic Abuse Perpetrator Programme, also known as the DAPP, aims to help people who have been abusive towards their partners or ex-partners to change their behaviour and develop respectful, non-abusive relationships. I think that may be a tad misleading, given that no women have been placed on a DAPP programme, because they don't exist for women. So, I have helpfully suggested my own amendments for Cafcass to consider. The Domestic Abuse Perpetrator Programme, the DAPP, aims to help men who have been abusive towards women to change their behaviour and develop respectful, non-abusive relationships. The Cafcass website then states, in most cases, Cafcass will assess a person's suitability for the programme and will check whether it is available locally. Once again, this appears to be entirely misleading. So, for a second time, I am happy to suggest an alternative text. In most cases, Cafcass will assess whether a person has a penis, and if so, will check whether a programme is available locally. Of course, the misleading lack of transparency on the Cafcass website also raises some other interesting questions. What happens if you have a vagina? What is the position of Cafcass and the courts if you once had a vagina but now have a penis? Or conversely, you once had a penis but now have a vagina? If a person in the near future is wanting to have a penis, would it be in their best interest to wait until the conclusion of all child arrangement proceedings, hence avoiding the potential of ending up on a DAPP course? Let's now look at the Cafcass DAPP fact sheet, along with its cute little photo of the little people that Cafcass claim to protect. Unless, of course, the perpetrator of abuse is a woman, in which case let's just quietly brush that one under the carpet. You see, the inference appears to be very clear, where you have two parents. The parents with a vagina can't commit domestic abuse, emotionally harm children, or be coercively controlling. I can only assume that the position of Cafcass not to refer women to DAPP courses must be down to biology, genetics and nature, and has been scientifically evaluated by some very clever people indeed. However, I can't remember being taught that at school, or indeed, come to think about it, even at university, where I studied child psychology. So what I think needs to happen is that all children from nursery school age should be taught that mummy is a good person who will never harm them and will always protect them. But if she separates from daddy, then daddy turns into a monster who's going to hurt them and mummy. At least that would avoid the current confusion, and we can all be on the same page. On continuing to read the DAPP fact sheet, I was immediately drawn to where it states that all DAPPs provide a women's support service to give separate support for your former and current partners. That's interesting on two levels. Firstly, it says to provide a women's service to provide support for your former and current partner, which clearly implies that when they say your, the fact sheet is referring to you as being a man. Secondly, it is indeed marvellous that there is separate support for women victims. Unless, of course, you are a man who has been domestically abused by a woman, in which case you don't count. Is that because as a man you need to suck it up, big buttercup? But what happens if the mum has abused the child? Does the child also have to suck it up, little buttercup? Or if very tiny, suck it up, baby buttercup? It's time to put on your big child pants and get used to mummy's abuse, because the family court doesn't care. You see, mummies can't abuse children if they look after you, because they have a vagina. And one day they will teach you the difference between nice mummies and horrible daddies at school. Now my alarm bells are ringing and something simply doesn't feel right. I'm not sure that I am personally convinced by the Cafcass approach or their inferences. Let's see if we can resolve this by looking at some facts. The judiciary itself published figures from the 2019 crime survey, which categorically states that an estimated 1.6 million women and 786,000 men experienced domestic abuse. That tells me that during that period, rounded up, 33% of victims of domestic abuse were men. From simple logic, that ratio and percentage split must transfer into the family court arena. So, it is baffling, incredulous and incomprehensible to read in a published Freedom of Information request to Cafcass, where they replied with the following. In 2018-2019, 909 men were referred to a domestic abuse perpetrators program by Cafcass. In the same period, no women were referred to a DAPP by Cafcass. Ladies and gentlemen, is this nothing short of institutionalised discrimination against those of us who, by some unfortunate quirk of genetic fate, were born as a man with a dingly-dangly, fleshy trunk-like appendage? Well, let's examine exactly that point in relation to equality, fairness and potential discrimination. Let me now refer to the Equal Treatment Benchbook, which provides the official guidance to the judiciary. Within it, it states the following. A judge must be free of prejudice and partiality and conduct themselves in and out of court so as to give no ground for doubting their ability and willingness to decide cases solely on their legal and factual merits, as appears from the exercise of an objective, independent and impartial judgment. We also know, as explained by Cafcass and their guidance, that the court has the power to require a party to attend a domestic violence perpetrators programme by imposing a contact order using section 11A or 11C of the Children Act 1989. Well, if on comparative domestic abuse behaviours, judges send men on a DAPP course but don't send women and treat women differently, then they are not deciding cases and outcomes solely on their legal and factual merits. Their judgments are not impartial. They are being dictated by the fact that there are no DAPP courses for women. Their orders are not based on objective criteria. How about this, reading further into the Equal Treatment Benchbook? Does this not prove my point? It says, fair treatment does not mean treating everyone in the same way. It means treating people equally in comparable situations. Exactly. The entire emphasis on fairness is treating people equally in comparable situations. So, for example, and I am not condoning any of these behaviours in any way, where a non-resident parent man slaps a woman, slams doors, shouts abuse, is disparaging and coercively controlling, and where children are harmed, they may end up on a DAPP course, whilst restricted to letterbox contact with their children. But where a resident parent woman slaps a man, slams doors, shouts abuse, is disparaging and coercively controlling, where a child may be harmed, they have continued and unrestricted access to their children. How is that treating people equally in comparable situations? What am I missing? The Equality Act of 2010 identifies gender as a protected characteristic, part of our equal worth as a human being. Direct discrimination is based on the premise that like should be treated alike. Under Section 13 of the Equality Act, direct discrimination means less favourable treatment because of a protected characteristic. It looks at the way the alleged discriminator treats the claimant compared to how he or she treats a comparator. In this case, let's present an argument that the discriminator is Cafcass, or even perhaps the court itself, in that it is treating the man less favourably than the comparator, the woman, in not having equal outcomes in terms of judgments in relation to domestic abuse, with no provision for women to attend a DAPP. So, what can people do? Well, I have to add this caveat. I can't tell you what to do in your own case. I'm not advising you what to do in your own case. I don't know your case. I'm not your McKenzie friend. I can only share my very general and genetic thoughts as a layperson blogger, sharing my personal views and opinions on the family court system. Well, firstly, and obviously, on completing the C100 application, I would consider self-identifying and declaring myself as a woman. However, on a more serious note, where the resident parent raises allegations of domestic abuse, coercive control and child abuse, and the non-resident parent has comparative evidence and allegations in relation to their abuse, then should this not be raised from the very outset to start fighting back, particularly against spurious allegations, and to take a stand? Where there are comparative cross-applications, is it not right that the man should formally raise objections to the court in terms of a lack of equality and fairness in their potential treatment and outcome of orders, given that there are no DAPP courses for women? Any objection would appear to be fairly straightforward and reasonable, that any sanctions on similar facts being found must be equal. If the mother cannot be put on a DAPP, then the DAPP needs to be taken off the table for the man. If the mother has continued unrestricted access to the children with proven allegations of abuse, then surely the man must also have unrestricted access to the children. Should the following potential logic not be applied to the court? Given that the central obligation of the court is to be fair, if the court concludes that the behaviour of the resident parent mother reaches the threshold of a DAPP or DVPP course, then they must, under the principles of equality, order it. It is for Cafcass to then have a professional obligation to provide the provision of that course as ordered. If they can't, the mother's contact with the child must surely then be restricted by the court, as the welfare of the child is paramount. Residency must either be immediately passed to the non-resident parent, or if both parents meet the threshold of a DAPP, the child should be placed under a guardianship or care order until the course has been completed by one or both parents. If the court does not order it because Cafcass can't provide a course, then isn't that the tail wagging the dog, providing the inequality in the system? I suggest that the bottom line is that until there is a DAPP course for women, and until the resident parent has their access to children restricted in comparable circumstances to when the non-resident parent has their access to children restricted or denied, then the notion that the welfare of the child is paramount is, in my opinion, an absolute and total farce in the family court. It's a nonsensical joke, and to coin my own catchphrase, a total load of bollocks. Ladies and gentlemen, what I next uncovered in the Cafcass Domestic Abuse Pathway document was one of the most frightening and perverse things that I have ever come across, and sums up the incoherent, irrational thinking that perpetuates through Cafcass and the family courts. And I also say this in terms of someone who for 3 years was head of a policy and strategic planning department for a police force. The Cafcass document asks the question, is there evidence at this early stage of whether there is a primary perpetrator of coercive control or other specific behaviours? It then repeats this by stating, and I paraphrase, how has the abuse been perpetrated? Who is the primary perpetrator? Let me repeat that. Who is the primary perpetrator? So their strategic and tactical focus is not on the actual notion of abuse, their focus is on who is the primary perpetrator. So there is a system that appears to be actively engaging in a witch hunt for a primary perpetrator, while supporting the other parent, even though that other parent may themselves be abusers. What madness is this? This flawed and quite frankly obscene strategic approach potentially generates an entire system based on which parent shouts the loudest and who shouts first. Invariably, this is on balance going to be the mother in the vast majority of cases, because we know that men statistically are far, far less likely to even report domestic abuse. If I was head of the Strategic and Policy Planning Unit at Cafcass, that document would never pass my desk. It would have been put in the bin. What is also deeply concerning is this, where the non-resident parent has evidence of abuse by the resident parent, but prefers from the outset not to raise that abuse, taking the path of light, not hate, trying to sensibly and appropriately build bridges to move forward in the best interests of the child. But the resident parent takes the alternative path of hate, throwing every spurious, mudslinging allegation that they can dredge up. Then the non-resident parent is immediately identified as the primary perpetrator, and the system then picks them up and throws them under the family court bus. I think that's me done. I'm going to bail out and leave the very serious implications of all of this with you. But I am confident to bet that thousands of you will relate to this blog and may be outraged about this entire irrational, farcical and totally unacceptable situation. It's time for change. Thanks for watching. Okay.